Welcome everyone to tonight's Property Portfolio Solutions webinar. I'm going to, for the moment, just share my screen and pin up a couple of slides that we've got going here. So the webinar tonight's about the law and property. We've got Richie Muir from Lawlab, a seasoned veteran when it comes to the law and property and conveyancing and all that sort of stuff. And he's going to give us some of his insights into the law and property before we then open it up to what we think will be a very productive question and answer session. We do ask that you specifically relate to the law and property and not anything else specifically. Richie's expertise is you would suggest around conveyancing and those bits and pieces around the edges of conveyancing that deal with property and deal with all the things that we're all here to do and try and get ourselves into investment properties that will get us towards our goals of what we've got. So what's in this for you? We're going to have a little bit from our guest Richie, as I said, and then we're going to have question and answers. So I'm going to stop the sharing there, come back to here and say, Richie, welcome tonight. And I'm going to hand it over to you. So I'm going to remove, if I can find my mouse, remove that pin, and then I'm going to, oops, if I can find you, pin you. Pin, away you go.
Right, thanks very much, Jeff. Yeah, I'll start off by with a little bit of an intro about myself and Lawlab, and then we can kick on to some of the agenda topics we've got today. I'm a property lawyer and director at Lawlab. I've been Brisbane based since 2006. I actually did my law degree in Glasgow, Scotland, and I went to university there, and my parents still live there. I was born in Australia, but spent some time over there, hence doing my degree. So I've been in Brisbane since 2006, and joined Lawlab in about 2014. So we're quite unique in that we have a national practice where we have employed lawyers who go through a graduate program, and we like to use technology to make the process easier, more transparent and consistent. So myself and Lawlab, we act for a wide range of clients, including home buyers, property investors, developers, property funds, right through to PropTech businesses, real estate agencies, local government, and financial institutions. In those 7 years now, since 2014, since I joined and we went national, we've done over 44,000 conveyancing transactions covering every state and territory. So we've experienced quite a lot and all types of transactions in that time. So yeah, looking forward to sharing some experience this evening. And information about property laws and how they relate to property investing. Usual disclaimer from a lawyer, this is just general information, of course, but happy to chat one-on-one, tomorrow after the webinar, and I'm sure Jeff and Sean can share my details if they wish. Righto, any questions so far? Okay.
I think we're pretty right for the moment. We'll just let's get into it, and then we'll start playing after.
No worries. So yeah, the first agenda topic, first question I had was, who do you choose, a lawyer or conveyancer? And I get asked this quite a bit, but it's not necessarily a question of choosing a lawyer or a conveyancer. I'd even recommend choosing conveyancers over some lawyers. It comes down to choosing a good property lawyer, not a lawyer who specializes in another area of law, or is a bit of a jack of all trades. I often hear that settlement has been delayed because a lawyer is in court and can't attend settlement or can't give advice at a particular time. So really important that you're choosing a lawyer who does specialize in property and conveyancing rather than someone who might do family law or litigation or something like that. I often say that choosing a lawyer is like getting insurance. It's not something you sort of wake up in the morning and decide to, today I'm going to choose a lawyer, likewise for insurance, but it is something that, that you need to have when you need it. So the property investors, they do have some advantages choosing a lawyer over a conveyancer, such as lawyers can give legal advice, not just on the contract and the conveyancing, but other issues that may pop up from time to time, or even preparing certain documents that a conveyancer might not be able to do. And we often hear from conveyancers acting for other parties in a transaction that they can't respond or deal with an issue when it has arisen because they need to seek legal advice first. So that's going to cost that client extra money in getting separate legal advice and delay things, which could be at their risk. Now, another couple of things, clients choosing a lawyer are also covered by the Law Society Fidelity Fund. Okay, and that means that if there's been any trust account irregularities, if there's been any dishonesty by that lawyer, the Law Society essentially compensates them for that. That does not apply for conveyancers. Conveyancers may not be covered by their professional indemnity insurance if they step outside the bounds of what conveyancers can do and they start entering the area of legal advice, and where they're negligent, their insurer may not cover them. So some critical differences there between lawyers and conveyancers. But when you're choosing a property lawyer, once again, it's not just any property lawyer. You do need to choose a property lawyer who has experience in the jurisdiction. So where that property is, making sure they're experienced in that and trained. Second thing I'd say is that they need to be good value. So not necessarily the cheapest, but representing a good balance of quality and price. The old saying, you often get what you pay for, is very true when it comes to choosing the right property lawyer.
Richie, are property lawyers registered in every state, or you say you're based in Queensland and you obviously look after stuff here? Do you have to be registered in all states?
So our law firm is registered in the states we operate in. What happens is there's a mutual recognition between the states. So a lawyer will be registered. They'll be practicing. They'll get a practicing certificate in the state that they're usually based. But the mutual recognition means they can actually practice in any other state in Australia. And likewise, our law firm is registered with each law society in Australia. So when someone asks, "Are you registered?" That's the answer. It's slightly different to conveyancers. They are registered with their state conveyancing association and can only practice in that state. Queensland is an exception. Of course, there are no conveyancers in Queensland. Only lawyers can conduct property conveyancing in Queensland. You'll have non-lawyers who do conveyancing in Queensland, but they're done through a law firm. So you'll have like a property conveyancing paralegal, essentially, who work under a lawyer in Queensland. And yeah, the last thing I'd say in choosing a good property lawyer is making sure that they make the process as easy as possible. And for example, we do that by using digital tools like DocuSign, digital verification of identity tools, and an online communications and document sharing platform.
So you might never meet a client face to face then, if you're running with DocuSign and with digital type verifications. You may very well never meet face to face. Yeah,
it's almost a failure if we do have to meet a client these days. For most transactions in most states, we can do that online. So we still have we probably have more communication touch points with a client in that digital space and on the telephone than we would, compared to a traditional practice who might meet their clients face to face.
So the tyranny of distance doesn't exist in the legal profession.
Exactly. In most states and most transactions, there's always some exceptions to the rule. For example, if a client needs independent legal advice on a guarantee, in most states, that needs to be face to face. So they'll need to come into the office and do that. At the moment, New South Wales is the exception. The Law Society, after COVID, have acknowledged that we can do that remotely. Victoria passed some recent legislation essentially making everything digital, which is great. They're leaders in that. And we've just contacted the Law Society recently asking if they've changed their position so that they would accept independent legal advice remotely. They haven't yet responded. Certainly in Queensland, still needs to be face-to-face.
So the Law Society is Australia-wide, not state-based as well?
Correct.
Right, so the indemnity is Australia-wide, right? So that's where I was going.
Yeah. So yeah, so every law society has its own process with things like that, and of course, you know, conveyancing varies dramatically between each state and territory. So there's 8 jurisdictions, of course, that each have their own, you know, laws and rules and practices.
Yeah, like the default settlement date is 42 days here in New South Wales. It's something like 21 or something in Queensland.
Yeah, I mean, at the end of the day, everything's negotiable, but the standard that real estate agents will ask for is 30 days in Queensland. But you're often seeing that if buyers are getting advice before they sign a contract, they usually say 21 days for finance before it goes unconditional, and then there might be another 14 days for settlement. But yeah, Victoria is off anything between 30 and 90 days. But everything's negotiable when it comes to settlement periods, and of course it varies depending on the owner's requirements as well. You know, if you're selling a house, you may need more time. You may want a longer settlement because you have to find another property to move into. And
from a tax point, just putting on my tax agent's hat for a moment, you've got to be careful if you're selling a property as the vendor, because capital gains tax works on exchange, not on settlement. Whereas if you're a developer, it works the other way. So you just need to be careful if you're looking at, if you're in a negotiation for an extended settlement, you just need to be careful.
Yeah, yeah. We often see, particularly this time of year with the end of financial year, often see you know, people wanting to date contracts after the 1st July, but obviously to do that right, it should be, you know, there are other ways to do it, like entering a put and call option agreement to defer that CGT liability. So yeah, so yeah, I mean, the property laws and conveyancing vary between state and state. So at a point, you get someone who is experienced in that jurisdiction. And I guess you know, having a national conveyancing practice like ours, it means that you know, we both have the benefit of giving clients a service wherever they're based in Australia and wherever they're buying in Australia. And you know, if they do need to pop into an office to see us face to face, they can do that as well in our offices. Okay, so the next topic was structuring your purchase. And the question was, when would you buy in your own name and when you might set up a company or a trust?
This one's going to be interesting because we have our own views on this one.
Yeah, well, it definitely overlaps with tax advice, accounting advice. And as lawyers, we often say, you know, these are your options. This is what you might want to think about from a legal perspective. But we always recommend they speak to their accountant because there are obviously drastic differences depending on how you own a property when it comes to the taxation treatment of that.
It's interesting that a lawyer is bringing that question up, because from our point of view, we're always dealing with that from a risk point of view with the benefit of some taxation benefits. I often will talk to people about that because, yes, I might be able to come up with a 26% tax rate as opposed to a 47% tax rate. But at the end of the day, it's all about risk and quarantining that risk away from potential creditors and potential harm.
Yeah, yeah. And it comes down to the individual's appetite for risk. You know, some people will say, okay, well, you know, I'll expose myself to potentially more risk on something that may or may not happen if I get, you know, if the tax treatment is better for me. So it's really balancing that risk versus reward in relation to the tax treatment.
Exactly right.
So some examples. So okay, if you're an investor, you have a choice. Do I buy this property in my own name? Some of the reasons why you'd want to do that, probably, you know, tax benefits. If it's negatively geared, obviously there's the benefit of having that in your own name. You may not get.
But it should only be negatively geared for a short time, if at all, and then you end up with the same. If you take a long-term view to that sort of thing, negative gearing now is going to kick you in the arse later on.
Yeah, and that's why we say go and speak to someone like yourself who will give the clients that advice. We're not accountants, so we can't give that tax advice, but we can explain why they might want to consider doing it that way. And obviously, buying something in your own name is obviously easy, right? So the alternative is to establish a company or a trust with a corporate trustee. There's obviously various types of trust, but the most basic one is a discretionary family trust. Obviously, the benefits of that are not just, the benefits are mainly asset protection. So when you're, as a landlord, if it's a property, if it's an investment property, as a landlord, you're essentially conducting a business of renting out properties, right? There are things that can go wrong when you do that. There are things that your insurance may not cover you for. So you, as the owner of that property, is at risk in that sense. But also, so having it in a company or trust structure, I guess, adds that layer of protection. So if the owner, as a company or trust, was sued, you personally most likely wouldn't be exposed to that, right? The worst case scenario might be that company or trust, is sued, gets wound up, loses the property. It's essentially you're trying to ring fence your asset. Of course, when it comes to the bank will ask you for personal guarantee anyway. So if you default on your mortgage, even if you have set up a company and trust, they're probably still going to get you because you have to give personal guarantees. So the risk asset protection is more, not so much with the banks, it's more so with other factors, like I explained before. But there are things to consider if you're buying multiple investment properties. You may want to use separate structures for each of those purchases, because if you have them all under one entity, if you are sued or if you do default on one, it may come tumbling down like the domino effect. So you want to ring fence those properties. So yeah, I mean, that's a bit of an overview of why you might think to do so. Of course, there are effects, impacts of doing that, particularly with taxes, property taxes. So land tax, for example, a different land tax threshold. So if you own,
the big one is land tax, because a discretionary trust, particularly because there's no defined owner of the benefit, because of the potential beneficiaries, land tax doesn't have a threshold for discretionary trusts. So you've just got to be mindful of, and then it becomes a cost versus benefit analysis. If I really want to protect, then I should go to a discretionary trust, and therefore it's going to cost me. It's not just going to cost me setup; it's going to cost me, land tax over and above what I may have paid in my own name. Over time.
Yep.
But if personally you're laid up with investment properties and you have other properties in a discretionary trust, it's not going to help you anyway. So
and just to explain that further, there's essentially each state imposes land tax. Well, not all states have it, but most states have a land tax. And essentially they say, okay, well, any unimproved or site value of your land above a particular threshold will incur land tax. Now, your principal place of residence is excluded from that. So if you have, let's get Queensland, for example. So as a natural person, if you own investment property in your own name, you'll only get land tax if the value of that property or properties, the unimproved value, is greater than the threshold amount, which is around about 600,000. But if you own those in a company or trust, it's a much lower threshold. It's around about 350 or thereabouts.
Yeah, all those rates and things are on our website too. So we made sure that they were all there for someone to find if they really wanted to go looking, rather than go down those state government websites that are really difficult to find from time to time.
Yeah, exactly. And the other thing, of course, because it's state based. So if you're thinking about investment properties, if you bought 2 or 3 in one state, then you're more likely to go above the threshold and incur land tax. But if you bought those 2 or 3 properties in different states, you may still be under the threshold and not incur land tax. That's something to think about as well.
Yeah, it doesn't work like payroll tax where they add the whole country together and then take your share into whatever. Land taxes are particularly property-based and state-based. So you're going to be, yeah, that's a good point, Richie.
Yeah. And the only other thing I'd say, well, a couple of things actually. The first thing, to set up a company or trust is these days is relatively quick and easy. I mean, setting up a company, there are online providers who can do it essentially straight away, and ASIC charge a fee of, I think it's around about $500, $600 to set up a company. And a lot of online providers only charge a small fee, might be $500 or $50 or $100 in legal fees to set up that company up. And likewise for a trust, your accountant can often arrange for those sort of volume trust providers to set one up relatively quickly as well. And it's important to do it if you are going to sign a contract. It is important to get it set up, before you sign the contract. And we'll explore this a bit more detail later, because you need to, generally speaking, well, in some states, you need to make sure that the entity that will ultimately own the property is the one on the contract. You can get away with it in some states, but not others. So in those states where you can't get away with it, it's important to get it set up before you sign the contract.
And even when you use the and/or nominee, we might as well go to that right now. That if it's not set up at the particular time, you could end up paying stamp duty twice, couldn't you?
Exactly. Yeah. So
do we get the concept there? So if I buy a property and put my name and/or nominee on it, and I exchange today, and then tomorrow I set up a discretionary trust to hold that property, I've effectively sold the property because the entity did not exist at the time of exchange. I've effectively sold it again. So it's going to cost me double stamp duty to move it into that other entity.
Yeah, I can break that down into how the main states treat that. But yeah, so starting in Queensland, the Office of State Revenue considers that 2 separate transfers. There's the transfer from the seller to the original party on the contract, and then another transfer to the party ultimately goes on title. Okay, so there's 2 lots of duty, double duty in that sense. I guess I'll come back how to get around that, or how to deal with that. New South Wales, there are some exemptions, mostly for natural persons. So it's what's called a transfer not in conformity. So if you sign a contract, let's say I signed a contract, but I actually wanted it in my wife's name. That's okay. I can do a transfer not in conformity, and there won't be double duty. But in an example where I signed a contract in my name, and I actually wanted it in my family trust, or the trustee of the family trust that hadn't been established at the time I signed the contract, that's not going to get around it, and there will be double duty in that sense. Victoria is a bit more relaxed with the nomination, so that's where nominations, nominee and/or nominee is used mostly. South Australia as well, to some extent, you don't actually need to put and/or nominee in South Australia. You don't need to put and/or nominee in New South Wales either if it's a transfer non-conformity. So how do you get around that? Well, when I say around, how do you deal with that? If you have signed a contract, you realise you need another entity. In Queensland, essentially, you're going to have to rescind the contract and enter a new contract. You can't do that unilaterally. You're going to have to ask the seller for their consent. So we'll have to go, and we see this often. People haven't thought about it. They sign a contract before coming to us, and it's exchanged. So we contact the other party, the other solicitor, and say, hey, we're going to have to rescind it. We need it in this name. And they say, okay, well, yep, deed of rescission, new contract. That's going to be an extra anything from $500 to $2,000 in legal fees to sort it out. And and they usually charge like a wounded bull when it comes to that. It's what we call OPM, other people's money. So if another party is paying for it, the fees go up.
Because I've got you over a barrel.
Yeah. So that's why it can be expensive to get it wrong. And obviously, there's even for us, if our client is one asking for it, we'll need to charge fees for dealing with that as well. Won't be charged as much as the example I said, but there'll still be fees involved. So it can add up to quite a bit. And listen, the seller, it's unusual, but the seller may say no, or they may want to renegotiate the deal. They may, because they got you over barrel, they may say, okay, I've had second thoughts, and maybe I want more money, or maybe I just won't do it and sell to someone else. So
the scout model, the scout motto here, be prepared, is
absolutely
very much.
And you'd have to do the same thing in New South Wales as well in relation to a deed of rescission. So that's important. There are a few. I mean, in Victoria, there are a few exceptions to the rule as well, where some deals can be treated as sub-sales. So that generally occurs where you've signed a contract, but you flick it on for an unrelated party, but for you're getting a profit, and there's been or you got it under option, and there's been property development. So those kind of option deals where there's been things that have happened, you've actually got a DA on the property and things like that, that can incur double stamp duty as well. So, but yeah, your standard, I guess your standard, if you get in Victoria, if you get it wrong, it's usually a bit easier to nominate the right entity, as long as it's a related party. But if you're buying off the plan, the developer may have put in their standard contract, and they often do, that you would need the developer's consent to do a nomination. So it's not always as easy as you think it is in Victoria.
Okay.
Okay.
Yep. So GST and residential property. This is one that's basically started to rear its ugly head in the last couple of years, where the government have been trying to crack down on, I believe, overseas residents and what have you. So what they're doing is they're asking solicitors to either gain a certificate of Australian residency or tax status. Otherwise, you've got to hold a whole heap of money.
Yeah, well, there's two things that they brought out in the last few years. There's the foreign resident capital gains tax withholding regime, which we've touched upon, and there's the GST withholding as well. The foreign resident capital gains tax withholding regime was aimed at foreign investors, who would sell their property, disappear, not pay the capital gains tax. So everyone, doesn't matter who you are, needs to get, as long as the property is over $750,000 in value, when you're selling a property, you have to get an ATO clearance certificate. Otherwise, 12.5% of the price is withheld and paid to the ATO. The GST withholding regime is aimed at mostly at developers to stop phoenixing. So obviously that's when a developer will have their development company might be a project-specific development company, does the development. In the old regime, they'd collect the full amount of the contract price, and they'd be responsible to pay the ATO for any GST that they owe. But they would just liquidate and then not pay that, and then go and start again on another entity, and that's the phoenixing. So obviously the ATO realised this and brought out laws in 2018 and said, well, actually we'll get lawyers and conveyancers to collect the GST for us at settlement. So what happens is, if you're selling new residential premises or potential residential land, then everyone has to give a GST withholding notice, and that will say whether or not the GST has to be withheld at settlement. So that will be in those situations where there's a developer selling or anyone selling any land or any property as a business. Your mum and dad selling a new premises they've just built or a subdivision. If they're not in the business of doing that, then GST need to be withheld, although they still need to give the notice to the buyer. But yeah, all developers, what will happen is that at settlement, if it's sold in the margin scheme, then 7% will be withheld. Otherwise, 1/11 of the price will be withheld, and there's a few GST forms that the lawyers and conveyancers need to exchange with each other and the ATO. And essentially, the buyer's lawyer will collect the GST amount at settlement and pay that directly to the ATO. In an electronic settlement environment, which is most states, that's automatic. It's just paid directly to the ATO. In paper environments, and some settlements in Queensland are still paper, then obviously you need to collect the check and send it off to the ATO within a couple of days. So yeah, so pretty strict laws that the ATO have introduced, and it's certainly impacted the conveyancing process. Yeah, I don't think developers are too happy about it, but that's where we're at.
Sorry, there's a quick question on the chat line here. Is there any proposed stamp duty relief in the pipeline? If so, which states and what timeline? The New South Wales in the last budget talked about going to the New Zealand method of stamp duty, where it becomes a lot less, and you only pay stamp duty over time for the period you hold the property. Are any of the other states you might allude on that a bit, and talk about, are any other states talking about the same thing?
So, I mean, stamp duty, I think particularly New South Wales is like a huge amount of the state budget. Accounts for some ridiculous amount of state budget. So it's definitely a money maker for them. And but they did announce that they were looking at essentially phasing it out. But I think there's going to be a period of industry consultancy with that. I haven't seen any legislation introduced, but my understanding was that they would essentially, for every transaction, they would give the buyer the choice of either paying the stamp duty. And I think the idea was that it was only for properties under a certain value where they'd have the choice. I think for higher value properties, they still wanted stamp duty to apply. But yeah, they give you a choice. So either you pay the stamp duty, or you'd elect to have essentially what was in effect a land tax every year. So you'd pay a land tax rather than paying the one-off stamp duty. And
once you opted in, you couldn't opt out.
That's right.
From what I remember of the state budget, they were talking about a stamp duty of a fee of about, it worked out that after 12 years, you'd pay more stamp duty than you would have if you paid it up front. It was going to work really well for developers who might only own a property for a couple of years. They would pay much less stamp duty than what they would over a longer time, or paying it up front.
Yeah.
For first home buyers, if it was going to mean a significantly reduced amount of stamp duty, because $1 million property here is $45,000 in stamp duty. It's crazy.
Yeah, I mean, I guess the idea behind it was to free up the real estate market, free up the movement of labour as well. People, if you own a house and you have to move for work, there's large transaction costs involved in selling and buying again. So, the idea is to make it easier to do that. But obviously they need to replace, the hole in the budget with something. So the idea was for that ongoing land tax.
Until they started carving up the GST for all the other people that were, all the bleeding heart lefties who screamed blue murder when the GST came in. The states were going to not have stamp duty. Right. They weren't going to have payroll tax. There were a whole heap of things they weren't going to have. But as soon as the federal government started saying, well, we're going to lean towards looking after the pensioner and fresh food and all that sort of stuff, the state government said, oh, thank you, we'll just keep our duties.
Yeah. Who would have thought politicians would break a promise?
No, exactly. It's interesting. There's a question there. The Victorian budget that are talking about increasing land tax. In Victoria, you actually, if you buy a property and an investment property and you don't rent it out, the land tax is actually higher. They actually penalise you for not renting your property out.
Yeah.
So yeah, it's crazy.
Right, yeah. I think the property industry certainly wasn't too happy with the recent Victorian budget.
No.
I mean, I think there were some winners. I think it's mainly to do with all the surplus stock they've got in Melbourne. A lot of the apartments in Melbourne. I think they sort of and encouraging more off the plan purchases with some stamp duty concessions there.
Yeah, there are huge tracts. We've just come back from Melbourne, and there are huge tracts of land down there, big scars upon the land where the developers are just madly building suburbs. It's crazy. And then you look at the Marrickville through to Parramatta area here in Sydney. The prices of units in those sorts of areas have not moved in the last couple of years, even though we're having a property boom at the moment. So the property market can be fraught with danger, but if you know what you're doing and then you've got the right people behind you, there's plenty of money to be made out there.
Yeah, you do know, you do need to know what you're doing and get good advice. I mean, just recently, I've seen it quite a bit recently. Just buyers being asked to release their deposits on essentially off the plan contracts, so to developers. And when you're being asked to do that, you've got to ask, well, why does the developer need that money so bad? They may not be in a good financial position as they are. And if that's the case, there's a high risk that they're going to go into administration liquidation, and you're never going to get your money back if that's the case. So usually, when you buy off the plan, it's held in a lawyer's trust account.
Yeah, and the property's not going to get finished.
Settlement.
Yep.
I mean, there was a few big developers late last year who went under. I think pinned down in administration as of earlier this week. And even smaller developers, there's a high risk, and we've seen clients after the fact who've come to us and say, hey, what can I do here? They said, oh yeah, we'll release the deposit. I'll give you a percentage. I'll give you a percentage return on that. And of course they went under and couldn't get it back. So it's little things like that, and you often see, they're just a line, a clause or two in a contract, enabling the vendor to that deposit, and most buyers will be unaware of that. So you do got to be careful.
So generally, you wouldn't suggest to a client to let a deposit go?
Absolutely not. No, when buying off the plan, 100% no. Actually, we had a client a few weeks ago, and that was advice that, well, listen, if we can't act for you if you don't accept that advice, we've told you the risk, and it was a very, very risky transaction. We just said no, we certainly don't recommend that. Ended up not acting for them. If for an existing property, a mum and dad sale, it can be okay, as long as it's only released for certain purposes.
Generally speaking, you'd think it'd be for buying the next property. Yes,
but you have to be careful how the clauses word. You wouldn't just say it's released to the seller to buy the property. You have to say it can only be released to essentially directly towards settlement or as a deposit for that property. So it has to go through the lawyers or the agent's trust account, rather than to the seller directly.
Just going back
once they've got it, who knows, what they'll do with it.
Just going back to land tax for a moment. I don't know this one off the top of my head, and I probably should. Is there any relief in land tax for rural land if we are carrying on farming activities like cattle breeding and stuff like that? I don't think land tax is payable on primary production land, from memory.
Yeah, it's outside my scope of expertise. I couldn't
Ronnie, I'll check that one up and I'll come back to you offline, okay?
Hey, Richie.
Yeah.
Sean here, mate. I was just talking to a client today, and he was talking about partnerships, doing a duplex. So if you've got two people come into a partnership and they're doing a duplex pair, and on the back end, they're both 50-50, one wants to own one and one wants to own the other. Is there a way to manage the process so that they can not have to pay the double stamp duty on the way?
In some states, So New South Wales, as an example, it's what's called a Deta Partition.
Mm-hmm.
So if they purchase that property, say 50-50 tenants in common, and the idea is to subdivide into 2 lots, and they ultimately want, what would usually happen is, if Jeff and Sean own 50-50 tenants in common, 1 lot, that became 2 lots, they would both, that each lot would be owned 50-50 by Jeff and Sean. So Jeff would own 50% of 1 lot and 50% of the other lot. So, but if they wanted to own 1 lot each in full, that's when they'd have to do a transfer of 50% of each lot to each other.
Mhm.
That would usually incur stamp duty. But if you have a deed of partition, it essentially gets around that. So you're saving stamp duty if you have a deed of partition at the start.
Is that
So
part
you've got
of
to
the
do that up
contract?
front. Is the structures that they put together up front and a deed of partition, or is it better to go individual names and a deed of partition?
They would sign the contract together, 50-50
Mhm.
tenants in common. They'd be on title, 50-50 tenants in common, and ideally, once they've signed that contract, they can start, settling the terms of the deed of partition. And the deed of partition essentially just, says, okay, well, we'll subdivide the land, and once it's done, you'll own 1 lot, I'll own the other. There might be a few clauses around valuations and mortgages and things like that. That will that essentially the stamp duty laws allow you to do that, and you get that stamp duty discount.
Just New South Wales or other states as well?
Victoria, you can do that in Victoria, and I mean Queensland talks about a deed of partition arrangement, but the stamp duty discounts aren't it's negligible. Essentially, it's effective really in New South Wales and Victoria.
Thank you.
Jeff, I think the other topic was foreign bylaws.
Can I interrupt there?
Who are we talking to?
Chris,
Yep, fire away,
Hey, Chris.
Chris.
you're supposed to have the petition in place before you buy it. And has to be on every sub property. So if you've got 6, you're going to have 6 townhouses, you need to cover the whole 6.
Yeah, you just had the 1 deed of partition if it was a 1 into 6. You just you obviously need a lawyer to draw it up. But yeah, it's okay to do it once you sign the contract. I think as soon as you sign the contract, it's probably best to get advice before you sign a contract to make sure that you're actually buying it in the right tenancies. So if that's something you're thinking about, get advice up front.
Because it may not work for joint tenants as opposed to tenants in common. Is that what you're saying?
Sorry, I missed that.
It might not work for joint if your contract's joint tenants rather than tenants in common.
Yeah, that's right. Exactly. Yeah.
Do we understand the difference between joint tenants and tenants in common, everybody?
Happy to explain
Yeah, I think
that.
you should.
Yeah,
I think you should.
Yeah, I mean, joint tenancy has essentially the rule of survivorship. So if one party dies, then the other party assumes all the property essentially. Where your tenants in common, and I should say joint tenants, so they sort of both own the entirety, and one dies, the other party gets it. Tenants in common, you can still have 50-50, we can have other percentages. You could have 90-10, 1-99, whatever it is. But when one party dies, then their share is passed according to their will, which may or may not be the other party, right? So yeah, that's essentially it. And you can have it essentially any fraction, any percentage of the property. You can have multiple. You can have 3 parties as tenants in common or more. Yeah, hopefully that's answered that question. But yeah, I think the last topic was foreign bylaws. Is anyone still interested in that?
Absolutely, because I know we've got a couple of people here that want to know about the bits and pieces.
Yeah. Okay. Well, there's two main things to think about as a foreign buyer. Number one is the Commonwealth laws for FIRB approval, whether that's needed. And
Foreign Investment Review Board, everybody.
Yeah, sorry, Foreign Investment Review Board. And the second thing is the state laws in relation to stamp duty, and in particular, the foreign surcharge duties or additional foreign acquirer duty, and as it's called in Queensland, or FPAD, foreign purchaser additional duty in Victoria. So most states have those additional duties. So yeah, the first one, do you need FIRB approval? Well, I guess you'll only get FIRB approval. You're only allowed to buy a property as a foreign buyer if it's a new property. There are some exceptions. If you're a temporary resident, you can buy a home to live in whilst you live here, and then you must sell it afterwards. So generally speaking, you have to buy a new property, so new premises or land which you're going to build a new property on. So you can get a FIRB pre-approval, and that will essentially allow you to buy a new property within 12 months in a particular state. There's an application fee. I think $6,350 at the moment. For properties under $1 million, properties over $1 million, $12,700, and it keeps on going up. You have to make sure that if you are signing a contract, that you've either got FIRB approval for that property, got FIRB approval in advance, or you have a special condition in the contract making the contract conditional upon you getting FIRB approval within a particular time. You usually say 30 or 45 days. And the review board audit contracts, and they come down heavily, and they can impose significant penalties if you haven't done that. So it is important you have that FIRB approval, or that subject to FIRB approval clause in your contract. So yeah, so that's the Commonwealth part of it. And then sorry, I should say there are some exceptions to that as well. If you're buying a property with your Australian or permanent resident or New Zealand spouse as joint tenants, then you won't need FIRB approval. It gets a bit more complicated with the state stamp duties. So if you're those additional duties, we were talking about 7 or 8% in stamp duty for that's on top of stamp duty, the normal stamp duty for foreign buyers. So it's a significant amount. It started out a few years ago as 3 or 4%, and they've gradually increased it, making it a little bit more unattractive. So there's additional duty. If you're buying with someone else who's an Australian citizen, in that example, you could be caught, right? If you're buying a property as a joint tenant with an Australian spouse, you don't have to pay the FIRB approval fee of $6,300, but you may still have to pay the essentially the foreign surcharge duty on that 50% that you own. There's an exemption in Victoria where you don't have to do that if it's your home. But yeah, other states still have to pay that 50%. If you decide, okay, well, what if my if my Australian spouse owned 99% of the property, I own 1%, you'd significantly reduce your stamp duty, your surcharge duty, but then be hit with the FIRB approval fee. They kind of get you both ways. So if you do have an Australian spouse, often it's and you're buying your home rather than investment property, it's often best just to buy an Australian spouse's name. You can always transfer your principal place of residence. You can transfer half of it to the then foreign person at a later date once they become permanent resident, and you can do essentially a spouse transfer of your home 50-50 without any duty. So you can do that after the fact. But yeah, for property investors, you're going to be foreign buyers. They will incur that surcharge duty. So you need to factor that in when you're budgeting and buying property.
Does that exemption for including your spouse into a property work in reverse, like when a divorce situation? Is there a stamp duty on the transfer of property in divorce? In
a divorce, if it's pursuant to a binding financial agreement or a court order, most states have, I think all states have an exemption to stamp duty.
I was asked that question the other day, so
yeah,
that's a good one to know.
But it has to be that official document, either a binding financial agreement, which is approved by the family court, or a court order.
Yeah, so you do your property settlement and you take it and get a rubber stamp by the court.
Yep. Yeah, and then take it to your lawyer and they can effect the transfer.
So how often can I do that then? If I bought a property and I add my spouse to it, and then I get divorced.
How many times do you think about getting divorced?
We'll take it away and then meet another spouse. Is the second spouse able to go on with no stamp duty?
Yeah. If you owned your home, got divorced, transferred it pursuant to court order, no stamp duty, sold it, bought another property just in your name, got married again, you can transfer half to your spouse, no stamp duty, got divorced again, transferred it back to you, sold it. Yeah, you can keep doing that.
All right. And the other day I did a transfer from a husband and wife of an investment property into their superannuation fund. And because the ultimate beneficiaries in the superannuation fund were the same as the owners, there was very little stamp duty in that transfer as well. That's the same.
Yeah, there's an exemption for stamp duty where essentially what's called the bear trustee or the custodian trustee, essentially the holding trust, which is usually set up for the non-recourse borrowing arrangement or the limited recourse borrowing arrangement. So where an SMSF has to borrow money, they have to set up a holding trust to own the property. When they've paid down the loan, that holding trust can then transfer the property back to the SMSF to own the property, and there's no stamp duty on that.
Yep, and the SMSF can't re-borrow against that property. It can only ever borrow once against that property. It can refinance the deal, but it can't increase the borrowing. That's a good one, a good trap for young players, that one. So we're getting on towards the end of an hour. Have you got anything else specifically you want to talk about before we, and I think we've covered most of the questions. I've been keeping a tab on the chat bot. Is there anything else you want to specifically talk about before I pull it back to this end?
I mean, the only thing I had on my list was the verification of identity requirements, but it's not particularly exciting, so I'm happy to skip that if time's at premium.
No, it's not at a premium. I'm just saying we're coming up towards an hour. I've got a question here from Gilbert, though. If you ask a lawyer for a tabled risk and impacts table when purchasing an investment property and someone else goes south on the property deal, how is it best to keep the lawyer accountable for their part in failing to advise on all the information for your sound and clear judgment?
If you ask a lawyer for a tabled risks and impacts table, they'd probably, I dare say, they'd probably want to charge you several $1,000s for that advice. And that's probably because usually when it comes to bespoke legal advice, you're paying a lawyer on an hourly basis. So what we usually do is when we review a contract for an investment property, so first of all, we've produced a buyer's guide, which is probably a 60-page document that covers all states, and essentially gives you advice on all the common risks and responsibilities and things you need to think about and costs and all that kind of stuff, and even the details about the process. And then, so we have that as a static document. That's a general document that we give to clients together with essentially a summary of their specific contract terms. And so that will usually be 2 or 3 pages of a table setting out the key terms of a contract together with our recommended changes on any of the clauses to protect them. So when you read those two together, that satisfies our clients in relation to what they need to know about a contract. But yeah, I dare say if you wanted a bespoke table with all the risks about that particular property, then they'd be charging you a significant amount for that. But in saying that, I mean, most off-the-plane contracts, there's no standard for them, but they do follow a particular, when you've seen thousands of these, and I draft them myself as well for developer clients, they sort of all follow a certain format. So 90% of the clauses in that contract will be as expected, what we say industry standard. And it's our job as lawyers to really point out the non-industry standard clauses to clients. So, okay, well, these 5 or 10% of clauses in here, these are industry standard. You should go back and renegotiate these.
Is that Is that like the contracts clauses that say that, hey, if you bought this off the plan, we have the right to give you something different?
So the laws generally say that a developer can make certain changes. So the rule of thumb is if you're buying a 100 square meter apartment, the rule of thumb is that a change up to 5%. So if you're getting 95 square meters, that's okay. If you get any less than that, that's what we call material prejudice. There are laws in each state that essentially say that a developer, when they do make change, so when a developer sells off the plan, there's a bunch of disclosures they have to give. Queensland's been very good at the types of disclosures that developers have had to give. They have to disclose, obviously, the proposed plan. If it's in strata, then the proposed budgets and levies. There's the schedule of finishes. There's the community management statements, has the bylaws. There's the agreements that the body corporate will enter into with caretakers and letting agents. New South Wales introduced the disclosure statement a couple of years ago, I think it was now. So there's more disclosure in New South Wales about that. Victoria's had a section 32, so that's always applied as well. So if you sign a contract off the plan and the information in that disclosure statement or vendor statement does change, most states require the developer to send you essentially an updated version. So that's called a further statement in Queensland, for example. And the laws will generally say, well, if the buyer has been materially prejudiced by those changes, they may have a right to terminate the contract within a certain time frame. So it comes down to what is material prejudice. So, we'll often, a developer will often send these out, towards the end of a project, and it might be hundreds of pages of, they might just resubmit the whole disclosure statement again. The good ones might explain what changes have been made, and that's significant work in that. So there's extra cost in having to review those. And clients who've changed their mind about buying the property, they might come to say, hey, well, is there any way we can get out of this contract? Have there been material changes? Or maybe they're just concerned that they're not getting what they bargained for, and need us to review that. Certainly the developers have in the past, we've seen plenty of developers make material changes, and we've been successful in having the price of property for those clients who didn't want to get out, but actually wanted to proceed with the purchase, negotiate significant price reductions because of that. I hope that answers the question, but there are changes made, and 5% is the industry standard. We do see sometimes some cheeky clauses really saying that any changes up to 10% of an area, or are fine and not material prejudice, or the developer can do X, Y, and Z.
I've seen that with property, particularly Meriton in the early days, would sell you a 3-bedroom unit and you'd get a 2-bedroom one, and they'd say there wasn't a material change.
Yeah, well, they'll probably point to, well, what was in the contract. Sometimes the plans don't say how many bedrooms there are, but in that case, I mean, if the agent and the developer made representations to you, so they were selling you a 3-bedroom property, and you got a 2-bedroom, you may have a claim against them for misrepresentation. So it's also critical, if someone's entering into a contract based on certain representations, that the contract needs to reflect those. And you need to tell you, well, hey, I've been told this about the property. It wasn't in your summary advice. Is that because it's not in the contract? And if it isn't, then that's when we have to go back to the law and say, hey, our client's been promised this needs to go in the contract. If it's not in the contract, often the contract say, well, if it's not in the contract, then any essentially no previous representations are valid. It's only the contract terms apply.
Fair enough. And Stefan, would you like to unmute yourself and ask that question? I don't understand what you're trying to ask. Is he still there?
Yeah, no, it was just you said they sent out these updates, and what we're given
Display, yeah,
in the
disclosure
contract.
statement, the vendor statement.
Yeah, vendor statement.
Yeah.
So unless you actually take direct action and question these updates, it just automatically, that is what you get.
Yep.
Okay, that was my question.
Yep. So if you get it, you know, if you get these further statements or variations to plan, whatever it is, and yeah, you just ignore it, the opportunity to either, you know, terminate the contract or negotiate a better outcome is lost if you don't do it within the time frame.
Fair enough. I'm going to unpin you for a second because I'm going to stick your contact details up on the screen for the moment. So there's Richie's contact details for anyone who wants it. Everything here is recorded, of course, and you'll find them on our website, and the lovely Pearl will be sending them out to everybody, the link to it when we get it chopped and changed and everything ship shape, because we started a lot earlier than 7 o'clock. But yeah, Richie, we've been gas bagging for an hour. We could gas bag for another hour more, I suspect, and not really get anywhere in. It's all about individual legal advice, isn't it? It's not about one shoe fits every foot. We've got to get to and make sure that we're prepared. The Scout motto, "Be prepared," is very, very evident here, isn't it?
It is, yeah, it is. And the most critical time is getting the advice before you sign a contract. And listen, I mean, obviously we've brought up, you know, scary examples, but you know, 90-odd% of transactions go through fine, go through smooth. The biggest challenge really is finance, getting the bank to do things on time. But you know, you don't want to be one of those, you know, small percentages who have a problem because you're rushed into something without getting good advice. Yeah,
we try to make sure that our clients have got their finance in place before exchange. But I tell you what, that makes things a damn sight easier.
Absolutely. Yeah. Yeah.
All right. Is there any other questions? It's past 8 o'clock and my wife and I haven't had our dinner yet. I'm sure Richie hasn't either because he's still in the office. Any questions before we go? Otherwise, I will wrap it up. Good. Thanks, Richie. It's been great having you on. Sorry, Chris. Go for it.
I know that South Australia, who started the torrent system based on duplicate titles, these days they don't issue titles. It's just all electronic.
Yeah, I think it's great. The amount of times that settlements have been delayed because you know, titles have been lost in the post with paper certificates of title, and then there's a massive process to get a new paper certificate of title issued. You know, you have to, in Queensland have done away with paper titles as well, but you had to advertise in local paper, pay for that, wait 14 days, then submit a copy of the cutout of the paper, send it to the Land Titles Office, issue another one, get a bunch of statutory declarations from everyone you knew had touched that paper title. So it was a massive process. So I think it is a better system, and now, of course, you can settle electronically. There are a bunch of measures in place to prevent fraud. So you have to be essentially a lawyer, a conveyancer, to use the electronic transaction system, which is currently the PPS system, or a bank. And essentially, the banks control. They control. If you've got a mortgage, the banks control the title, the electronic title. So you can't just transfer your property. You can't get your lawyer to transfer the property. You have to have the bank come in. So okay, we'll allow you to do that as long as you know, pay the mortgage. So yeah, there are measures in place to prevent fraud. And obviously, with things being more electronic, and that was something we didn't talk about today, but one of the big changes with the introduction of electronic settlements was verification of identity. So there's certain steps that lawyers and conveyancers have to make to verify their clients, and it's much higher standard than it used to be.
So if it's a higher standard than it used to be, how common are the discrepancies in the paper titles that used to come up?
So the high standard for verification of identity, I mean, it used to be, you know, probably just a copy of the driver's license used to suffice back in the day. So the law essentially requires, well, if you're using PPS, the law requires you to take reasonable steps Reasonable steps is you're deemed to comply if you do what's called the VOI standard, which is a face-to-face meeting with 2 original identity documents, i.e. passport and driver's license, or if they don't have one of those, then a birth certificate, and there's a few other, a list of things. And so that face-to-face, there is a digital solution for that, which we have. So what you can do, so rather than actually having to go and see a lawyer or going to Australia Post to offer that service, you can, if you have a smartphone, which most people do, you can actually take a selfie and then take the photo of your original documents, nominate someone else to essentially do the same for themselves and confirm that you are who you are, and that information and pictures run through the government database, and essentially there's this legal tech firm who produce the VOI report saying yes, all these things are original based on our tech. It's confirmed with the government databases. This is who they say they are. So yeah, really handy solution rather than having to go in person to someone to confirm who you are.
All right, Stefan, the question was more around boundary points, I think. You all, when we do a property transfer, you basically do a survey anyway, don't you, to make sure? Well,
so there's all the essential Torrens title is surveyed, but before Torrens title there was essentially what they call
the old system
general
title.
land, yeah, old system in New South Wales and general land law in Victoria, and they're slowly being converted to Torrens title. But often you see on the titles when that's happened, there's a notation saying that the boundaries haven't actually been identified. So on some titles you still see that, and there's a waiting period essentially until no one has made a claim about those boundaries or until it gets surveyed. Most people don't get property surveyed. I mean, it's recommended, but it's expensive. I've never surveyed any property I've bought, probably just due to the expense and the likely, there's, I guess it's relatively lower risk in a urban residential area.
Yep.
But it's certainly not uncommon to hear about boundary disputes and encroachments. So it's not uncommon for fences not to be built, not actually on the boundary. They're built over the boundary, people fighting about that, or they might have built, a house with eaves or a shed with eaves going over someone's property boundary. It often causes disputes. There is a thing called title insurance that you can get. So if you didn't want to do a survey, get a survey done, you can pay for title insurance, a one-off insurance policy, and that covers you for any boundary issues, so any losses based on boundary issues and encroachments, but also unapproved structures. So if someone's done alterations to a property that haven't been approved by local council and you suffer loss, that title insurance will cover you. Once again, it's insurance, so it's not cheap. It could cost you, $500 to $1,000 depending on the property value. But it's a once-off payment and it does cover you for those things.
All right, I want to change the subject for a second. There was a case that put shivers down my spine not so long ago of some people who were squatting in a house, ended up owning the house. Well, how does that work? If I've got the title deeds and the title deeds are in my name, how can someone effectively squat on, and a squatter's right still real? They obviously are.
It's called it's called adverse possession. So the law recognises essentially squatters' rights if they've essentially used that land for a certain time period, and I think it's quite it's close to 20 years or thereabouts.
So I should throw my long-term tenants out?
Well, if it's through a tenancy, that's different, because you have a contract there about it's still your property and you just give them a tenancy. But someone who's actually being used, and it's even common in rural settings. If you've used the land, you might have enclosed it yourself. You've used it. You may have even improved it. No one's bothered you with that. Maybe even they're aware and they didn't bother you. You just used it. You've essentially taken it on as your own. then you can be granted that adverse possession and you're entitled to that property.
So the properties out west that are on the PP system, that's because that's a tenancy agreement. Effectively, they're not just squatting.
Yeah. So I mean, I think the one you were talking about in Sydney, it was a dilapidated house, and yeah, people just opened the door and moved in, and
well, the real estate
landlords
agent,
didn't.
the real estate agent
owners
changed the locks, I think, from memory.
Yeah.
And then these people moved in. It seemed very coercive. Yeah, coercive was probably the word I was looking for. Yeah.
Yeah. I mean, I guess the law recognises that you can't just leave a property indefinitely and not do anything with it. So if someone comes in and is there for a long time and uses it as their own and no one questions it, they may have rights.
So 20 years is the number, Richie.
Oh, don't quote me on that, but it's a significant time. Yeah.
Fair enough. All right. Well,
it's 20 years in New South Wales under the Torrens system.
Okay.
So you move, you've got to pay all the rates and taxes as if you owned it. So someone else is paying the rates and taxes, you could lose that 20-year right. Now, I heard of a case.
Yeah, it's absolutely. It's not it's rare, put it that way. It's rare, but people can take advantage of it.
Yeah, I think in that particular case, the real estate agent was paying the rates out of his own pocket. There was all sorts of coercion in it. There was it'd be worth a look if you really want to scare yourself.
Yep.
But everyone, it's getting late. I'm going to say thank you to Richie on behalf of everybody, and I'm going to close this all up now. You putting your hand up, were you, Sean? No, he's on mute, so we don't have to listen to
I was just saying, thanks, Richie. Good on you, champion.
Thanks, Sean.
Thanks for helping us out, mate.
And thanks, guys.
Thanks, everyone.
It's been really informative tonight, Richie. I think we might have to have you on again in the not too distant future.
Glad to help and share some experience.
And Richie's a person that we like to use. We found his services to be not only efficient but effective and in the right sort of cost area for us. So yeah, thanks, Richie. Thanks everyone for being here, and we'll see you all soon.
Excellent. Thanks again.
Thanks,
Good night, everyone.
guys.
See ya.
Thanks, guys.
Bye.